Our next speaker is Jeanne Hepler. She was on our organizing committee. She attended our organizational meetings, as my preacher friends will tell you, and she was very helpful. She wrote the letter, which is in your packet. I hope you'll read that. And she's going to talk to us today about paying for long-term care. So, Jeanne, would you come up, please?
Hi, I'm Jeanne Hepler. I'm with the firm Collins and Hepler in Covington, and I'm an elder law attorney. And I'd like to talk to you about paying for long-term care, which usually means nursing home care. Most people don't plan to spend their final years in a nursing home, and most families I talk to say, we're going to keep our loved ones at home as long as we can, but sometimes people develop illnesses that are so debilitating physically or mentally that they're not able to be cared for at home. So I'd like to go through with you what happens when a person needs nursing home care and specifically make you aware of the financial ramifications of that. Because I found that this is something that a lot of people don't really fully anticipate. They don't fully understand how it works, and there's a lot of confusion about it. So I'm going to walk through it with you using a fictitious person, John, as an example. So John is over the age of 65, and so he has Medicare. So if John has a stroke, he may end up being hospitalized for a while, and he may end up being placed in the nursing home after his hospitalization for rehab. And Medicare will pay for his hospitalization and for the nursing home rehab, but only up to a maximum of 100 days in the nursing home, or less if John is not continuing to make progress. If he's not making progress in rehab, Medicare stops paying. And that's because John has ventured into what's called long-term care, and Medicare doesn't pay for long-term care. If John, instead of having a stroke, if he develops dementia and is unable to be cared for at home, Medicare will not pay for his long-term care either at home or in a nursing facility. So what about Medicare supplements? A lot of people have Medicare supplements through AARP or other companies. Will they pay for long-term care? No, they don't pay for long-term care. So if Medicare and Medicare supplements won't pay for nursing home care, then who does? Well, John does. John has to pay for his own care out of his own pocket. And how much does this usually cost? In Virginia, it averages between $5,000 and $9,000 a month. The state average is $7,452 a month. That's over $89,000 a year. And most people can't afford that kind of care. Most families can't afford that kind of expense. Now, there is a governmental program that will pay for nursing home care for those who can't afford it, and that's Medicaid. But there are financial requirements for Medicaid. You have to meet certain financial conditions in order to qualify for Medicaid to pay for your care. So if John had a brother named Bob, and say Bob didn't own a home, or if he did, it was mortgaged to the hilt, Bob didn't save his money, he didn't live frugally, he didn't really have anything. If Bob needed nursing home care, Medicaid could kick in right away and he could be eligible from day one to have his care paid for. But John, who's been the more frugal brother, has a house that's paid for, he's got CDs, he's got IRAs, he's got some money in the bank, maybe a good life insurance policy with some cash value. John can't qualify for Medicaid assistance until he goes through what's called Medicaid spend down. So once he spends down to the amount that Medicaid requires, then Medicaid will pay for his nursing home care. So how much does he have to spend down to? $2,000. He can only have $2,000 to his name before Medicaid will pay for his care. Now, if John has a wife at home, and I'm going to call her Mary, if he has a wife at home, then the house will be exempt. If John is a single man, he's going to have to sell his home and use that money to spend down to $2,000 as well. But for a married couple, the rules are a little bit different. Mary will be able to keep the home as long as she lives there. It's exempt up to a value of $585,000, which covers most people's homes in this area. Mary will also be allowed to keep a certain amount of the assets. Medicaid will allow her to keep roughly half of the couple's assets up to a maximum of $126,000. There's also a minimum of around $25,000. So what Medicaid does is they look at the assets owned by both John and Mary. So they're not just looking at what John owns or what John and Mary own jointly, but also what Mary owns in her own name. A lot of people are surprised to find that, if the wife has inherited property that has nothing to do with John, Medicaid is still going to count that as an asset that's available to pay for John's care. So they look at the assets that John and Mary both own. They exempt the house if Mary's living there. They can have one vehicle that's exempt, and prepaid burial plans are exempt. And then they divide the rest in half, and Mary can keep up to $126,000 of that. So if the couple has a total of $30,000 in countable assets, Mary can keep $25,000 because there's a minimum that she can keep. But if the couple has a total of $500,000 in countable assets, they have to spend down until Mary has $126,000 left before Medicaid will pay. So if this couple has, say, $250,000, which is pretty common for people around here, pretty frugal, this couple would have to spend down about $123,000 before John could qualify for Medicaid. So, a lot of people ask, well, what if I just give my assets away? Then I don't have any countable assets and I could qualify sooner. The problem with that is that there's a 5-year look-back period for Medicaid. Medicaid is going to look back 5 years to see what John or Mary have given away or sold for less than actual value. And any gifts that are made like that are going to cause a penalty period to be imposed by Medicaid. And I want to explain how that works because a lot of people aren't clear on this. A lot of people have heard of the 5-year look-back period, and they say, well, if I deed my house to my child and I need nursing home care within 5 years, Medicaid is going to come and take the house away from my child. That's not how it works. Medicaid is not going to go after the assets you gave away, but Medicaid is going to impose a penalty period when you are ineligible for Medicaid and Medicaid won't pay for your care. And the length of the penalty period depends on the value of the gift. So the bigger the gift, the longer the penalty period. And what's really important to understand is how this penalty period works, because the penalty period doesn't start when you make the gift. The penalty period starts when you're otherwise qualified for Medicaid. So to be qualified for Medicaid, you have to have less than $2,000 in assets, or different for a married couple. You have to be sick enough to need long-term care, so you have to be medically qualified, and you have to file a Medicaid application. So the penalty period of ineligibility doesn't start until you're broke and can't pay for your care, and you're too sick to stay at home, and you need to be in a nursing home. Then the penalty period will start, and Medicaid will not pay for your care. And of course, the nursing home is going to have to send you back home if you can't pay your bill. So it puts people in a really hard spot. So I want to make sure I'm covering everything I wanted to talk to you about. So, after laying out the depressing scenario, is there anything that that John can do. That's where something called Medicaid planning comes in, and this is something that some elder law attorneys do. Typically, it's kind of a subspecialty. We can protect assets. Medicaid planning attorneys, elder law attorneys can help John to qualify for Medicaid without losing all of his assets. Well, how do we do this? We basically use Medicaid's own regulations against them. We find loopholes. Much like tax planning attorneys will use loopholes in the tax code to help wealthy people avoid paying taxes, Medicaid planning attorneys will use loopholes in the Medicaid regulations to help regular people protect their assets. So how much can we save? It depends on the situation and what kind of assets the couple has or the person has, whether it's just real estate or whether it's liquid assets like bank accounts. But typically for a married couple, we can protect almost all of their assets. And for a single person, since the rules are different, we can generally protect around half. That's a rule of thumb, and it really varies depending on the situation. But I just wanted you all to be aware that while it's easy to go broke in a nursing home, 65 to 70% of people who are in nursing homes nationwide are using Medicaid to pay for their care. And it is possible to qualify for it without losing everything. You can get help. And it's generally worth the price of a consultation to find out what we can do. You know, if your loved one gets a diagnosis of dementia, that's a good time to go in and start making some estate planning, some Medicaid planning decisions. But it's never too late. Even if your loved one is in a nursing home and you're already in spend down, as long as there are assets left, come in and see, you know, how we can help, because it's usually possible to do something. And that's what I wanted to talk to you all about. Do I have any more time? I'm out of time. Be happy to answer questions during the break. Thank you.
Thank you.